Good afternoon, everyone. Thank you for joining today's webinar. I'm Ratin Sinha, SVP of Compliance and Diversity Solutions here at JobTarget, and I'll be your moderator. This webinar is hosted by JobTarget, a trusted partner for businesses nationwide, providing seamless job posting, distribution, and reporting solution for federal contractor OFCCP compliance. Beyond compliance, JobTarget is a leader in recruitment marketing solutions, including programmatic, marketplace e-commerce, and various recruitment technologies to enhance hiring results. On January 21 of this year, President Trump issued Executive Order 14173 titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This order rescinded the provisions of Executive Order 11246, which required affirmative action for women and minorities, while also keeping the provisions of the Vietnam-era Veterans Readjustment Assistance Act, commonly known as VEVRAA, that requires federal contractors to take affirmative action to recruit, hire, promote, and retain qualified veterans, as well as Section 503 of the Rehabilitation Act of 1973 that requires federal contractors take affirmative action to recruit, hire, retain, and advance qualified people with disabilities. Since the announcement, contractors have been grappling with how to wind down their affirmative action plans for women and minorities, while at the same time comply with VEVRAA and Section 503. They are also navigating potential False Claims Act liability or enforcement actions from the EEOC and Department of Justice, and determining what diversity initiatives they can continue at what constitutes illegal DEI. So today our goal is to address these questions and concerns. We are privileged to have Matthew Camardella, our esteemed guest speaker, to help us navigate these issues. Matt discussed these topics with many of you earlier in February, right after the new executive order was issued. And he's here again today to share his updated perspective, equipped with more information from the administration and agencies. Now, before we proceed, a few words about Matt. He is the principal and co-chair of Affirmative Action, OFCCP, and Government Compliance Practice Group at Jackson Lewis P.C. Matt oversees the preparation of thousands of affirmative action plans annually and has successfully defended hundreds of OFCCP audits for employers nationwide. He also leads responses to OFCCP allegations of class-based discrimination and advises organizations on AAP structures, applicant flow tracking, compensation practices, and other complex compliance matters. So along with me, Robin Feynman, legal counsel of JobTarget, will be a panelist. She will be coordinating the question and answer session. So please send your questions, but use the Q&A using the question mark on top of your screen. If you look at it, there are a few icons there. In the middle, there is one that has a question mark. And if you click on that, you will be able to submit your question. And do not use the chat box. Instead, use this one. And also note that we will provide a copy of the presentation and a recording of the webinar within 2 days of the event. So now, without further ado, let's hand it over to Matt. Matt, all yours.
Great. Well, thank you, Ratheen, and happy to be here with everyone once again. As Ratheen mentioned, we tried this once before, immediately in the aftermath of the issuance of Executive Order 14173, when everything was quite new and fresh, disruptive, and now we've had a few months for things to settle down. And so our goal today is to, essentially review what happened, take stock of the time that has taken place since the issuance of the executive order in terms of what folks are doing, what folks are expected to do, some additional information that we've seen coming out of the government, and hopefully address those questions that you might have on your continuing compliance obligations since the issuance of Executive Order 14173. So with that, our agenda is we're going to do a little bit of a overview and a review of some of the things that we discussed in that earlier webinar, which is basically to provide you with the context and background for the executive order, what the executive order changed, importantly, what the executive order did not change. We also have a clearer picture of what the OFCCP's role with regard to government contract compliance is going to look like moving forward. We're going to talk a little bit about those things that if you haven't already done them or in the process of doing them, you want to be doing as far as unwinding your Executive Order 11246 affirmative action plans and technical requirements. We're going to talk about an emerging issue, which is continuing to perform some sort of non-discrimination analyses in the absence of an executive order plan covering women and minorities, and why that might be an appropriate solution for you, and then address hopefully any questions that you have. Okay, so let's talk about the Executive Order 14173 and what it changed, right? How it changed things. So let's start with what contractors historically had to do, right? And historically, federal government contractors and subcontractors were required to comply with 3 laws and their implementing regulations that dealt with equal employment opportunity, non-discrimination, and affirmative action in the workplace as it related to women and minorities, protected veterans, and individuals with a disability, right? So Executive Order 11246, the first of those laws, required non-discrimination and affirmative action as it relates to race and gender. Right? The Vietnam Era Veterans Readjustment Assistance Act, or VEVRAA, required non-discrimination and affirmative action for protected veterans. And then Section 503 of the Rehabilitation Act required non-discrimination and affirmative action with regard to individuals with a disability. So those 3 laws and their implementing regulations essentially created a laundry list of obligations for contractors, right? Besides those generalized do not discriminate and undertake affirmative action directives, right? The first and the most onerous was the requirement to prepare affirmative action plans. So there were 3 laws. So contractors and subcontractors had to prepare 3 different affirmative action plans for each of their locations of a certain size, ensuring that all of their employees were included in an affirmative action plan somewhere. And so you developed a plan for women and minorities under the executive order, a plan for protected veterans under VEVRAA, and a plan for individuals with disabilities under the Rehab Act. You also had to certify on an annual basis to the OFCCP that those plans were in fact developed. So for the last several years, the OFCCP required at the end of June that a contractor or subcontractor go into a portal maintained on the OFCCP's website and certify that the plans were developed. Now, in addition to the requirement to prepare these affirmative action plans, there was a very long list of what we call technical compliance obligations embedded in those regulations. Everything from required workplace postings to taglines in employment advertisements, to flow down provisions in your purchasing agreements, to how you went about your outreach and recruitment, including, for example, the requirement to list jobs with the state employment service. So a long list of technical compliance obligations were embedded in the implementing regulations for those three laws. In addition, contractors and subcontractors had to file EO1 reports and VETS 4212 reports, right? So those are reports on, in the case of EO1 reports, race and gender makeup of the workforce. And in the case of the VETS 4212, the makeup of the workforce as it relates to protected veterans. Right? And then lastly, but certainly not least, government contractors and subcontractors were subject to periodic audit by the OFCCP under all three laws. So if you were so lucky as to have to go through an OFCCP audit, you received a scheduling letter. That scheduling letter asked you to supply a copy of each one of those affirmative action plans for the establishment being audited, and then to include a whole host of additional information that was included in an itemized listing, which was an attachment to that letter. And all of that got submitted to the OFCCP. The OFCCP went through its audit process, sometimes including an on-site phase, and at the conclusion of which the agency either found you to be in compliance or found you to be in non-compliance, right? If you were in non-compliance, depending on the nature of that non-compliance, was it technical non-compliance, or did the OFCCP believe that you discriminated against a group of individuals? But depending on the non-compliance, that would dictate the remedy available to the OFCCP, everything from just a commitment to come into compliance versus, in the worst case scenarios with discrimination claims, actually paying the victims of the alleged discrimination. The OFCCP conducted, historically, maybe about 2,000 or so of these audits each and every year. All right. So historically, that is what federal government contractors and subcontractors were required to do. Then, as Rathine mentioned, on January 21st, President Trump issued Executive Order 14173, ending illegal discrimination and restoring merit-based opportunity formally. Opportunity, which formally rescinded Executive Order 11246. Now, it does more than that, which I'm sure many of you are aware of, because this executive order addresses the issue of diversity, equity, and inclusion programs in the private sector more broadly. But one of the components of that executive order was the formal rescission of Executive Order 11246. All right. So then what does that mean, right? It means, right, that the executive order affirmative action requirements were eliminated and everything that was attendant with them. All right. And it explicitly said that government contractors are barred from considering all of the traditional protected characteristics when it comes to making employment decisions. Now, what's somewhat strange about that is those were the requirements under the executive order, VEVRAA, and the Rehab Act anyway, right? So Executive Order 11246 did not permit government contractors and subcontractors to discriminate on the basis of race and gender, right? It actually prohibited that. In fact, it said you must ensure equal employment opportunity, and the affirmative action plans were the vehicles to help you do that, right? But nonetheless, this Executive Order 14173 recast contractors' obligations to non-discrimination. All right. The next thing that the executive order did as it relates to government contractors, which is really important, is it will require in future contracts that contractors agree to a new provision in the contract, which one, requires the contractor to affirm that they are not engaged in illegal discrimination, including illegal DEI, and affirm that that provision is material to the contract. All right, that latter affirmation of materiality is important because it brings the that provision of the contract under the auspices of the False Claims Act. For those of you who are not familiar with the False Claims Act, this is a statute that was originally promulgated in the wake of the Civil War, and it was designed to be an obstacle to government contractors defrauding the federal government. All right. So the False Claims Act is a vehicle by which anyone can allege that a federal government contractor is in a material way defrauding the federal government in its provision of goods or services. When I say anyone, it means anyone. It can be an employee, it can be a concerned citizen, and then the government has the opportunity, if it so chooses, to intervene in that particular case. So what is really interesting about the False Claims Act is it's essentially a whistleblower statute, right? It incentivizes private individuals, including employees, to report government contractors who they believe are defrauding the federal government, and they get a piece of any of the damages that are collected if the claim is successful, right? So this creates a lot of anxiety and angst for government contractors because they are certifying, right? They're affirming that they are not engaged in illegal discrimination, including illegal DEI. Now, the executive order doesn't define illegal DEI, so it's somewhat difficult for an employer to know exactly what is or is not violative of Title VII. But nonetheless, if an employee thinks you're violating the law, they can file a False Claims Act claim. Right? And then the government can decide whether or not to intervene or to let the person proceed individually. Right? Now, one really critical aspect of 14173, it does not change the underlying non-discrimination statutes of the federal government. Right? So federal law as it relates to non-discrimination is unchanged by this executive order. All right? Title VII is still the primary federal statute that governs employment and non-discrimination in the workplace. All right, coupled with a handful of other federal statutes, we have our class of protected characteristics, which enjoy protection when it comes to tying those characteristics to employment decisions. All right. Okay, so what's changed? First, you no longer have a requirement to prepare an affirmative action plan for women and minorities, right? And you are no longer required to adhere to all of those technical requirements that are contained in the implementing regulations for Executive Order 11246. You are no longer subject as a government contractor to an OFCCP audit for compliance with Executive Order 11246, because there is no Executive Order 11246. Now, there is an outstanding question, and we still don't know the answer to this, as it relates to audits for compliance with VEVRAA and the Rehab Act. So shortly after Executive Order 14173 was issued, the acting director of labor, Secretary of Labor, issued a directive to the OFCCP instructing the agency to immediately shut down any audits as it relates to Executive Order 11246 and to freeze the components of the audit related to VEVRAA and Section 503 compliance. Right? So any of you who may have had an open audit at the time of Executive Order 14173, you would have received a notice, a letter from the OFCCP saying your executive order audit is closed, and the other two components of that audit, VEVRAA and Rehab Act, are actually frozen, right? They're being held in abeyance. There has been no communication from the OFCCP since on those frozen aspects of the audit, and we don't know what will happen going forward. So we'll talk a little bit more about some changes at the OFCCP that may impact this issue, but right now, we don't know about existing audits and what's going to happen with those. We also don't know the future of audits, right? What's going to happen going down the road with OFCCP or a different federal agency who may have responsibility for VEVRAA and the Rehab Act, right? And then there's this certification requirement, right? I mentioned it on the last slide, and it's not just showing up in new contracts. Right? We are seeing federal agencies send letters, emails, forms, all with different language and all in different formatting, asking federal government contractors to certify that they are not engaged in illegal discrimination, including illegal DEI, and affirming that that is a material clause to the contract. Now, there's been some litigation around this, and there's been some stays issued and then stays lifted, and then there have been TROs issued in other cases. So the legal landscape with regard to the certification is far from clear, and it's far from decided at this point. But understand, you may very well see, whether it be in new contracts or for that matter, in some communication with the federal agency with which you are contracting, asking you to certify your compliance with this new obligation, all right? And it creates that False Claims Act liability. So you need to think long and hard in terms of, well, how can you actually make that affirmation? How can you make that representation? A little bit more on that in a bit, right? What hasn't changed? Right? Many of your core obligations have not changed. You still have to prepare affirmative action plans for protected veterans and individuals with disabilities. You still need to comply with all of those technical compliance obligations under the implementing regulations for VEVRAA and the Rehab Act. Why? Because those are statutes. The president cannot eliminate a statute. The president can rescind or modify an executive order, but only Congress can rescind or modify a statute. So those statutory obligations remain. All right? You must continue to ensure non-discrimination on race and sex, as well as any other basis protected under federal, state, and local law. You are still required to file EEO1 and VETS 4212 reports. We'll talk about in a moment how the EEO1 reporting for the 2024 period is about to open up. So we're going to have that obligation coming up very, very quickly. The VETS 4212 reports are due a little bit later in the year by the end of September. You are technically still subject to the jurisdiction of the OFCCP as a contractor or subcontractor as it relates to compliance with VEVRAA and the Rehab Act. As I mentioned before, it's still a question as to what that jurisdiction will look like and whether there'll be audits. But nonetheless, at least for the moment, the OFCCP has responsibility for those statutes. And what happened on a federal level with Executive Order 14173 does not affect any of your state or local law obligations. So if you have an obligation to prepare an affirmative action plan for women and minorities because you're, say, a state contractor to the state of Minnesota, this does not change that. You still need to have an affirmative action plan for women and minorities to contract with the state of Minnesota, right? Your government reporting obligations, right? California has a pay data reporting requirement. Oh, by the way, today is the due date for that. So if you haven't already done it and you're required to do so, please make sure you do after the webinar. This executive order does not change your state reporting requirements. All right? So a number of things have changed, but as we can see, a number of things have not. All right? So let's come back to this concept of what is illegal DEI. I mentioned that the executive order does not define it. Shortly after the executive order was issued, maybe about 2 months or so later, Department of Justice and EEOC issued joint guidance on illegal DEI. This is sub-regulatory, right? This is not a change or promulgation of a new regulation. It doesn't technically change the law. this is just how EEOC and DOJ in the Trump administration are thinking about what type of DEI is illegal. Now, just to be clear, from this administration standpoint, all DEI should stop, whether it's legal or illegal, and that would be their preference, right? But they have thoughts in terms of what is illegal and what isn't, all right? But basically, any type of employment action that's motivated in whole or in part by race or sex or any other protected characteristic for that matter would be illegal DEI. And so I've bucketed the examples that they give in that joint guidance into three parts, right? So first is this concept of disparate treatment. That's where you actually base an employment decision on a person's race or gender. So for example, if you decided to hire a Black applicant into a VP position because let's say you had underrepresentation of Black individuals at the VP level, and that was the reason you made that decision, that would be unlawful under Title VII, regardless of the guidance. Right? But that's an example of disparate treatment. That's actually explicitly tying a selection decision to one of those protected characteristics. The second bucket is what we call limiting, segregating, or classifying, right? Meaning that there are programs associated with employment in your workplace that limit participation based on a person being of a certain demographic. So for example, having a career accelerator program that is reserved for female employees, right? That is arguably unlawful. Certainly the DOJ and EEOC would consider it to be unlawful because it excludes males, right? Having a fellowship program or an internship program that is only open to individuals in college who are people of color, right? Arguably unlawful. DOJ and EEOC would certainly consider it unlawful. But those are examples of programs or activities that are limiting in some way. And then the third bucket, it has to do with the type of training that you may do, right? Over the years, the concept of non-discrimination training has really expanded to go beyond just what the law prohibits, right? It included historically, non-discrimination requirements, non-harassment requirements, but it has gone on to include things like implicit bias, right? And other types of topics that generally fall under this notion of ensuring equal employment opportunity, but also might be considered more on the DEI side of things. Well, the DOJ and the EEOC have basically said, look, depending on the content of that training, making people sit through it may constitute a hostile work environment. All right? So for example, if you had a training for employees, let's say managers, and during that training, your trainer told all of the white employees that they have to go sit in a corner somewhere so they know what it feels like to be excluded. Well, that might be an example of a situation where those folks feel like they're being subject to a hostile work environment. And the EEOC and the DOJ, if somebody were to file a charge with them, they might agree with that and they might take up the case. All right, so we've gotten a little bit of guidance in terms of what is illegal DEI. All right. So then we have another executive order that was recently issued. There have been a lot of them, so sometimes it's hard to take place to keep track. But this one is labeled Restoring Equality of Opportunity and Meritocracy. This administration likes using those terms a lot. But in a nutshell, under US employment law, there are two types of claims that can be brought alleging discrimination. Right? One is called disparate treatment. We already talked about that, right? That is where you base an employment decision on a protected characteristic, right? That is unlawful, provided it's true. The second type of claim is what's known as a disparate treatment claim. I'm sorry, disparate impact claim. Disparate impact is a situation where you have a facially neutral employment practice that has the unintended consequence of negatively impacting one group more predominantly than another. Think strength test as part of an application process. Depending on how rigorous that test is, you could see how more women might fail it than men, okay? In those circumstances, an individual can bring a claim of discrimination, even though the employer did not intend the discrimination, if the employer cannot justify the use of that employment practice, right? So if an employer gave a strength test to applicants for every position in the workplace, including, for example, like receptionist or customer service rep, right? The question is, well, why do you need to be able to pass the strength test in order to do this job, right? Is it job related and consistent with business necessity? If the answer is no, well, then it's discriminatory, right? And even though it wasn't intended to be so, it is nonetheless discriminatory. So what's the impact of this executive order? Well, it's kind of unusual, frankly, but basically the executive order instructs the federal EEO agencies, so EEOC, Department of Justice, Department of Housing and Urban Development, not to consider disparate impact when trying to decide whether or not to bring claims. In other words, don't bring claims that rely on a disparate impact theory of discrimination, whether it's in employment, in housing, whatever the case may be. Right? So if, for example, an individual files a charge with the EEOC saying that they were subject to some employment practice that had an adverse impact, disparate impact on them and others like them, this executive order tells the EEOC, don't consider that. Issue the right to sue letter and let them pursue it themselves. Now, this is really odd, frankly, because Title VII explicitly includes a disparate impact theory of discrimination, right? It was originally supported by the Supreme Court and then codified later in an amendment to Title VII. So the president's executive order is instructing federal EEO agencies not to follow the law, which I think is kind of unusual, but nonetheless, this is where we're at, right? Now, that doesn't mean that in a situation like I described, the use of a strength test, that the EEOC would ignore every charge of that sort. If somebody brought a claim saying that they were subjected to a strength test, and they think it was because the employer was trying to keep women out of these jobs, the EEOC still might be interested, because that's what we call a pattern and practice case. It's really a disparate treatment case that is on a class basis as opposed to an individual basis. All right, so we're going to see more coming out of the EEOC on, what exactly the agency is going to prioritize and deprioritize. But the big takeaway here is that the federal government does not seem to be interested in pursuing disparate practices in the workplace. Okay, so let's talk about the OFCCP. I mentioned before that there have been some changes, certainly since we last all spoke together. So let's talk about what those changes are. Well, the OFCCP got a new director a few weeks back. Her name is Catherine Eskbach. She is from Big Law, and she hit the ground running. So on the first day in the job, she sent a memo to all of the OFCCP employees, which was promptly leaked. And she set out her plans, her priorities for the agency. And just a couple of them here, which I thought were noteworthy. One is she wants the agency to somehow verify that employers have wound down their Executive Order 11246 affirmative action plans. Doesn't say how, but that's one of the priorities. Second, she wants to review the regulations for VEVRAA and the Rehab Act to see if anything about those regulations somehow violates recent Supreme Court precedent in cases, specifically the Loper-Bright, the Jarkissi, and the Students for Fair Admissions cases. For those of you who are Supreme Court wonks, the Loper-Bright case dealt with the issue of Chevron deference when it comes to federal agencies, right? Should the courts defer to the federal agency's interpretation of a law, or should the court be doing that themselves? The Jarkissi case dealt with, it was an SEC case where a company that was accused of violating securities law went through an internal adjudication process within the SEC with their administrative law judges. And they claimed that that was unconstitutional, that they really had a right to a jury trial in front of an Article III judge. And the Supreme Court agreed there. And the reason why these relate to the OFCCP is you could see in this administration how the new head of OFCCP might look at some of the regulations implementing VEVRAA and the Rehab Act and decide that, hey, these regulations don't adhere to these Supreme Court precedent, right? Maybe something that we included in these regulations really is an inappropriate interpretation of the statute, or as many of you may already know, if you are on the receiving end of a claim of discrimination by OFCCP and they want to go to enforcement, that enforcement mechanism goes through an administrative law judge process, right? Department of Labor judges sit in judgment initially of those types of claims. So that's a long way of saying that the OFCCP is going to reassess their implementing regulations, including their enforcement mechanisms. Right. And then this last bullet, this is the one I think that is frankly most frightening for employers who are subject to OFCCP, and that is she has directed her agency to review previously submitted materials in an audit from government contractors to see if there's any evidence of illegal discrimination in that documentation. And so if you've been through an audit and you've submitted a whole bunch of information on good faith efforts and the various things you have done historically to ensure equal employment opportunity and non-discrimination, that information could potentially come back to haunt you if the OFCCP identifies it and then refers that information to, let's say, the EEOC or Department of Justice for some sort of investigation or enforcement action, right? Very, very surreal to find yourself in that position. All right, so that's something that she's put on her priority list. Now, there's a lot of priorities here. And as you probably have been reading, the OFCCP is going through a dramatic change from an organizational perspective, like the rest of the federal government agencies. All of their non-essential staff have been put on paid leave, and formal layoff notices have gone out to those individuals just last week, I believe it was, if not 2 weeks ago. So the OFCCP's plans are to get down to 50 employees from about 500 during the Biden administration. So with 50 employees, I'm not sure how much the OFCCP can or cannot do, but it's questionable in terms of how many of these priorities the agency will get to. All right. Anyway, her activities have certainly drawn attention. Former OFCCP officials have voiced their opposition to what the agency is up to. And just recently, several House Democrats wrote a letter in their oversight capacity to the director, asking her to explain some of the things that she is up to and how those align with the statutory requirements under the law. So this is an evolving issue. Okay. I mentioned earlier that EEO reporting is still a requirement, and just a few weeks back, the EEOC asked the Office of Management and Budget to approve a non-substantial change to the instructions for the EEO reporting, which they just got approval for yesterday. So assuming these dates hold true, the portal for filing your 2024 EEO report will open up in a week or so, and it'll close by June 24th. So that means you'll have to file your reports in that window. The non-substantive change that took place was, in the last few years, the EEOC instructed filers that if they had employees who self-identified from a gender perspective as non-binary, that they could be reported as such in the comments section of the reports, because the reports themselves, when it comes to sex, only have male and female, right? This change instructs filers now not to do that, but to put all employees into one of two sex categories, male or female, pursuant to Executive Order 14168. All right, so you're a federal government contractor. You've seen all of these changes now, and you're trying to figure out what it is you need to do. Well, some of this stuff we touched on, but you're going to discontinue the executive order plans, those plans covering women and minorities, and you're going to unwind your technical compliance. We're going to go through some examples of what that looks like in a moment. You're going to continue to prepare your affirmative action plans for protected veterans and individuals with a disability. One thing we'll spend a few more minutes on in just a moment is whether or not you want to continue to do some sort of non-discrimination analyses as it relates to race and gender, even in the absence of the mandates of Executive Order 11246. And in light of what I just mentioned about the OFCCP going back and reviewing prior audit submissions, if you have undergone an audit in the last 3 to 5 years with OFCCP, we are strongly recommending that you review a copy of everything that was submitted and flag for yourself anything that you think the OFCCP might look at and question as potentially illegal DEI. Not because there's anything you can specifically do about it with the OFCCP, but in case you are still doing something that may be questionable in the eyes of the OFCCP or any of the federal agencies, this will give you an opportunity to change course, right? To revise, remediate, change anything that you are doing that you think is risky, so that if in fact you get a question, a letter, an investigation, you can show that you have changed something that may have been problematic previously. Okay, so in terms of unwinding Executive Order 11246 technical compliance, here's a list of a quick list of things that you'll want to modify. So first, pay transparency non-discrimination provisions that were required to be posted in the workplace and included in handbooks. No longer required, so that you can remove those. All right. Race and gender self-identification from applicants. You are no longer required to solicit that information. All right, so if you want to stop, unless you're otherwise required under a state or local law to do so, you may do so. Now, whether or not you want to continue to do it for non-discrimination analysis purposes, that's a complicated issue, and I would highly recommend that you speak to counsel before making a decision one way or another. But understand, at least under Executive Order 11246, you no longer have this obligation to solicit that information from applicants. All right, your policy statement. So federal government contractors had a requirement to post a policy statement for both employees and applicants to see under all 3 laws. Executive Order 11246 now being gone, that policy statement needs to be amended, right? It needs to remove references to the executive order. So this would be an opportunity for you to do that if you haven't already. Right? Your EEO taglines, right? So your EEO taglines in job applications and job postings, right? Previously, you were required to include certain protected characteristics. You're no longer required to do that, right? So you very well can remove references to race and sex and color, etc. You still need to include references to veterans and individuals with a disability, but you don't have to include all of the others. You can, if you like, right? But just make an informed decision as to whether or not you want to include the laundry list of protected characteristics. Right? The next three kind of fall within the same bucket, right? And that is purchasing agreements, vendor notifications, union notifications. Right, so under the old executive order regulations, you had an obligation to include a flow down provision in your agreements where you're purchasing goods or services that flow down the executive order obligations to your vendors and suppliers. In addition to doing that, you had to send those same vendors and suppliers a notice, a notification that they may be subject to Executive Order 11246 and its implementing regulations. And you had to send a similar notification to any unions that you had so that they knew what your non-discrimination policies were. All right. With the rescission of Executive Order 11246, you no longer have to reference Executive Order 11246 in these notices or agreements, but you still need to have these provisions there because under VEVRAA and the Rehab Act, you have these same obligations. So it's really just a matter of scrubbing out references to Executive Order 11246 in your purchasing agreements, your vendor notifications, and your union notifications. All right. And then there's the EEO1 reports. And if you are a small employer between 50 and 100 employees, right, so 50 to 99, you had an obligation to file EEO1 reports because of Executive Order 11246. Any employer, contractor or not, with 100 or more employees has to file. All right. So there's now this group of employers who have 50 to 99 employees. And the question becomes, do you still have to file an EEO1 report? Well, when we presented this slide, the answer was no, stop filing. But if you look at those newly approved instructions that I mentioned on the EEO1 report, the requirement to file is still there. We think it's a mistake, all right? But if you are one of those employers that falls into that bucket, I would advise you to speak to counsel and get their direction or opinion on whether or not to file an EEO1 report for the 2024 cycle. All right. So last in terms of sort of takeaways here, right? Review any EEO policies, internal, external communications, websites, proxy statements, those sorts of things, to ensure that you are not saying anything that might run afoul of Executive Order 14173. This is part of a DEI assessment, okay? So review all of your DEI initiatives, your programs, all of the communications associated with them. Make sure you're not shooting yourself in the foot, all right? Meet with key stakeholders in the organization to decide what your comfort level is with regard to DEI initiatives and programs, right? I'm not talking about your affirmative action plans. Those are required, right? It's anything that goes beyond the technical requirements of these affirmative action plans. And based on that risk profile, eliminate anything that doesn't align with it, okay? But don't do anything drastic, and don't do anything without a solid communications plan whereby employees still know that, hey, we're continuing to ensure non-discrimination in the workplace. We value our diversity and our differences, and we will ensure that it is an inclusive and good place to work. You don't want to make changes to your DEI programs and initiatives without accompanying communication strategy to make sure folks don't feel like they're being abandoned. Okay. All right, for the last couple minutes, what I want to talk about is this, it's really an emerging issue here, and that is whether or not to continue to do some sort of non-discrimination analyses when it comes to race and gender, okay? Executive Order 11246 is gone, all right? So that means that we no longer have a requirement to do these types of analyses as part of our affirmative action plans. But the absence of a mandate is not a prohibition, right? So that means that you as an employer can still undertake those types of analyses if you so choose, and knowing the risks of doing so and the burdens of doing so, if it serves a legitimate purpose, right? So one example of this is the certification I had been talking about earlier. How can you certify that you are not engaged in illegal discrimination, whether it's illegal DEI or just traditional discrimination, right? How can you certify that unless you have done some sort of evaluation of your employment practices? Well, some would argue that you can't, that you actually have to review your practices, right? And the way that you do that is through statistical analysis, right? So some employers have decided that, hey, we have to do these analyses in order to make that certification because I don't want to be, held responsible for a fraudulent claim that is subject to the False Claims Act because I didn't bother to look to see if we had any discriminatory employment practices. All right. So, that's one major pro, but there are others, right? It can help you stay ahead of claims of discrimination, right? Because you can identify potential issues before they arise in litigation or charges and that sort of thing. You can, design these analyses to align with the way that your workforce is organized, as opposed to designing these analyses around a compliance obligation of the affirmative action plans, right? So who gets included in the analyses, how the workforce is divided up, et cetera, et cetera. You have a lot of freedom when it comes to designing the analyses to work for you. You can actually support continuing diversity initiatives, right? The analyses can be the springboard, the platform upon which you are undertaking analyses. So if you, for example, know that you're underrepresented for women at director and above, well, for you to undertake lawful diversity initiatives to try to increase female representation at those levels, and where you are not basing employment decisions on gender, well, those would be perfectly lawful and they'd be justified in light of those analyses. The other major pro of doing these types of analyses is now you can do them under privilege. When they were a compliance obligation, you were not permitted to claim an attorney-client privilege, right? The affirmative action plans were not privileged. A non-discrimination analysis done at the direction of counsel for the purpose of dispensing legal advice, that can be privileged, right? So that's a major upside at this point of doing a voluntary non-discrimination set of analyses. Now, what are the downsides, right? There's always costs and benefits, right? Well, time, resources, and expense, right? Somebody has to do them. You need a lot of data. Somebody's going to have to work on that, right? So it's going to take effort, all right? Doing the analyses for the sake of analyses, not a good idea, right? So performing analyses and then ignoring them, that is a recipe for disaster, especially in a jury trial for discrimination, all right? You need demographic data in order to do this type of analyses. So whether it's on employees, whether it's on applicants. So if you're subject to EEOC reporting, you're going to have to collect race and gender data from your employees. That's still an obligation. But you're not necessarily obligated to do it for applicants, as I mentioned earlier. So you have to weigh the pros and cons of getting that data from applicants and whether or not you have a good justification, such as performing the non-discrimination analysis, to outweigh the risk of having all of that data or even asking in the first place, which in and of itself is not unlawful, but it may give the job applicant or a government agency the impression that what you're doing is unlawful. And oh, by the way, if you do these analyses, right, you collect the data, you do the analyses, if you're in a situation where there's litigation alleging employment discrimination, you're not going to be able to say, yeah, we didn't know that that issue existed because we didn't bother to look, and oh, we're not required to. If you've done it, obviously, and you're aware of it, you're not going to have the availability of the ignorance or we didn't know defense. All right. So what types of analyses can you do? You can do all types of workforce benchmarking analyses, what you look like compared to what you might think you should look like. You can do glass ceiling analyses, right? Where in the workforce, at what level do we see diminished representation of women and people of color? You can do disparate impact analyses of the types you did in your affirmative action plans on hires, promotions, terminations, performance rating distributions, right? Are there significant differences in selection rates or evaluation rates based on race or gender? And you can continue to do pay equity analyses, which I think are very important these days, especially with some of the state equal pay laws. All right. You're going to need lots of data, as I mentioned. So these are just examples of some of the things you'll need to make sure that your HRIS can produce in order to do the analyses. So before undertaking the analyses, make sure you have the underlying data and the ability to report out on it. All right. So that 55 minutes went pretty quick. So happy to open it up to Ratheen, yourself, and any questions that folks have.
Yeah. Before we go, I mean, so first of all, thank you very much for a wonderful, very informative, presentation. Just a brief comment on that. So in alignment with what you Matt just mentioned, our OFCCP compliance solution has also been, reconfigured to address all these regulatory changes. So we have divided the solution into two parts, a core compliance solution and an optional sort of add-on module. The core compliance solution includes, job postings to the state ESDS, job banks based on the job location, and distribution to job boards that are targeting veterans and people with disabilities. And the add-on helps customers to do exactly what just Matt mentioned, reach a broader audience by using niche, job boards to find qualified candidates. So our customers today, they can easily choose to opt in or opt out of this module based on their situation, their objective. And our overall compliance solution now is essential to meet OFCCP compliance requirements while also enabling employers to cast a wider net for potential qualified candidates. So with that, we'll come to Robin for the question answer session. We don't have that much time, but hopefully we can make best use of it. Thank you again, Matt.
Thank you, Ratheen, and thank you, Matt, for such an informative presentation. We have some great questions that have come in from the audience, so we'll try to get to a couple of those before we're up for time. So the first question we have is a clarification, to the extent we know, on illegal DEI. Would that apply to programs that focus on members of the military? So essentially, veterans, like an internship for members of the military transitioning into the workforce.
Yep. So federal anti-discrimination law as it relates to veterans protects veterans, doesn't protect non-veterans. So the fact of the matter is that in all likelihood, diversity initiatives that involve sort of preferences or legs up for members of the military or ex-members of the military is probably lawful. Now, as a general rule, I'm of the mindset that you always choose the best qualified individual for the job. But certainly if you want to make a concerted effort to attract, retain, develop, veterans, you certainly should have the wherewithal and the legal ability to do so.
Okay, great, thank you. Next question is a clarification question. Does the affirmative action plan for veterans and people with disabilities look like the traditional affirmative action plan, just without race and gender?
Yeah, so technically they were three different plans, right? Oftentimes, the consulting houses out there, for example, that prepared affirmative action plans would sort of smush them all together and then just have a whole bunch of exhibits that were the various reports required under the implementing regulations for each of those laws. The bottom line is that the affirmative action plan requirements for veterans and individuals with disabilities are unchanged. So it should be two separate AAPs with their own sets of reports and analyses. And those analyses in each of the plans is somewhat different. So you want to make sure that you're consulting with the regulations on that or whatever service provider or legal support you have with the development of your AAPs.
Okay, see if we could squeeze in one more question. And we have a question about job postings to state job banks. Are those still required, as well as engaging outreach activities?
Yeah. So the short answer is yes. Under the VEVRAA requirements, contractors and subcontractors must list all job openings with the State Employment Service with 3 very narrow exceptions. 1 for very senior executive level management positions, 1 for temporary positions of 3 days duration or less, and 1 for positions that do not get opened up to external candidates. Otherwise, everything else has to be listed with the State Employment Service. In addition, under both the VEVRAA regulations and the Section 503 regulations, there is a ongoing obligation to make meaningful and consistent outreach efforts targeting the veteran and disability community. Those requirements are unchanged.
All right, great. Looks like we are at time. The recording and the slides will be circulated, and we thank everyone for joining us today. Thank you.
Thank you very much.